The grandmother accused of child endangering in Ohio's so-called House of Horrors case has some big requests, and her attorney is telling us exactly what happened the day Christina Ciders and her family were arrested and taken to jail. I have all of the details. Christina Ciders is a grandmother and a mother. She's a wife, and she wants out of jail. Christina Ciders is accused of abusing 16 of her grandchildren by allowing them to live in conditions in a home in Vinton County, Ohio, that the sheriff said weren't fit for livestock. The children who were removed from the home, according to the prosecutor, suffered serious physical harm. The nature of the physical and emotional issues the children are dealing with remains under wraps, but we know all 16, including an 18-year-old, are in therapeutic foster care.
No evidence. Let that sink in. They raided her home on June 30th, took her in for hours of interrogation without a lawyer, and now her own attorney is saying the words the system doesn't want you to hear.
Christina Ciders' lawyer is asking that she be released from jail, and her attorney wants a mental health evaluation for her client. Attorney Kanda Roberts wrote, on June 30th, 2026, law enforcement arrived at defendant's home with the purpose of serving another member of defendant's household with an arrest warrant for unrelated misdemeanor charges. Nonetheless, defendant was detained and arrested outside her home. After providing a statement and cooperating with law enforcement during an interrogation at the Vinton County Sheriff's Office without counsel present, defendant was ultimately charged by complaint with one charge of endangering children, a second-degree felony for each of her 16 grandchildren who had been residing with their parents in defendant's rented home. Defendant has remained incarcerated since her arrest. I should point out, this was not just sheriff's deputies and agents with the state's Bureau of Criminal Investigation serving an arrest warrant on Gary Jr. for misdemeanor charges. Law enforcement has said they went to this home to execute a search warrant, searching for evidence of a crime they have yet to disclose. The manner in which those documents were sealed is being challenged at the Ohio Supreme Court. Bail is, of course, supposed to ensure that a person charged with a crime shows up for court. It's not supposed to be a punishment. Roberts cited case law, writing, if a court orders financial conditions of release, those financial conditions shall be related to public safety, the defendant's risk of non-appearance in court, the seriousness of the offense, and the previous criminal record of the defendant. Roberts continued, the court must consider the defendant's ability to pay. Setting a high bail in order to keep someone accused of a crime incarcerated pretrial is both statutorily and constitutionally unlawful. Christina Ciders' lawyer also questions the weight of the evidence against her. The state has charged defendant with endangering children, which would require evidence that on or about June 30th, 2026, defendant did abuse each of her 16 grandchildren, and that she caused serious physical harm to every one of the children. To date, the defense has received scant evidence suggesting defendant committed any of the alleged offenses. The weight of the evidence against defendant is minimal. In fact, to date, there is no evidence that has been provided which would support the finding that defendant committed any acts of abuse, let alone that any of the children suffered serious physical harm because of abuse by defendant. To date, the state has presented evidence only that defendant resided and was present in the home on June 30th, 2026, and that the conditions of the home were unsanitary to the extent that the removal of the children from the custody of their parents.
To date, there is no evidence that she committed any acts of abuse. Those aren't my words. That's straight from the court filing. Christina Ciders is a 66-year-old grandmother. 16 of her grandkids lived under that roof in Vinton County, Ohio. The sheriff said conditions weren't fit for livestock. Trash, feces, filth. Nobody is defending filth. But we all knew this, didn't we? The moment a case gets this ugly, somebody has to pay. The question is, are they paying the right person? You already know what I'm about to say. The system grabbed the easiest target, slapped a $300,000 bond on her, and buried the real story under sealed documents the Ohio Supreme Court is now being asked to pry open. They don't want you to see those case files. Not now. Maybe not ever. Here's the thing, though. Christina Ciders isn't some phantom landlord who just happened to own the house. She's grandma. She's the wife of Gary Ciders, sir, and the mother of Gary Jr. Their whole family got swept up when law enforcement showed up that morning supposedly to serve an unrelated misdemeanor warrant on Gary Jr. But then a search warrant appeared. For what crime? They haven't disclosed it. The documents are sealed tighter than a drum. And look, I'm not saying those kids didn't suffer. They're all in therapeutic foster care now, every single one. That's specialized care for children with deep emotional and behavioral wounds. That part is real, but here's where it gets interesting. Christina Ciders was not the parent of those 16 children. She was the grandmother living in the home. And her attorney, Kendra Roberts of the Ohio Public Defender's Office, is now fighting to expose what the prosecution won't say out loud. They have almost nothing tying this woman directly to any act of abuse. Just like I know that when the state overcharges and overholds, they're usually covering for a weak case. Roberts wrote it plain in the motion to reduce bail. To date, the defense has received scant evidence suggesting defendant committed any of the alleged offenses. The weight of the evidence against defendant is minimal. Minimal. She's been sitting in jail since June and able to scrape together even a fraction of that $300,000 bond, indigent, no criminal record. Lived in southeastern Ohio her whole life. Her lawyer argues she poses note to the public, she's no flight risk, and she has family ready to take her in if released. But the judge hasn't budged.
Let's move on now to the issue of bail. Right now, Christina, Gary Jr., and Elizabeth, they're all being held on a $300,000 bond. We know they can't post this. We get it. We know. So she wants her client released on bail. She said she has supportive family members who would make sure she gets to court appearances, etc. How likely is this to be granted a reduction in bail? Because we don't even have a grand jury indictment right now.
That's correct.
We don't know what the grand jury's going to do. So
there's no indictment, and actually she's not. She's now going to be examined for competency, and generally the psychologist would want the easy availability to the defendant, which is occurs when they're in custody. And so I think that the chances of a reduction are probably 50-50. And when I say that, it may not be a reduction that causes her to be able to post that bond, because public defender mentioned their means are very limited. And if I'm the trial judge and trying to insulate myself from perhaps a habeas corpus petition, which would be a basis to test the amount of the bail, I might reduce the bond from $300,000 to $100,000. Well, she can't post either of those bonds, but at least you have reduced the bond that was set, and the standard being whether the bond is quote unquote reasonable. The Ohio Constitution was amended because of some adverse, at least from the state standpoint, decisions on what should be considered by a trial judge. The Ohio Constitution was amended in 2022 to permit the trial judge to consider, in addition to may they appear at subsequent court hearings, to whether or not the public safety is served by that, and whether or not, in this case, probably applicable, whether or not there's any risk of further harm to victims. And in this case, where is she going to go if she was given a signature bond today? Well, the only place she has to go is back to the house where these children were held. I don't know what other family, when they talk about family support, I don't know whether family they have. That wasn't indicated. But besides her husband, who himself is being examined for competency, and the children, which are in the custody of adult or children protective services, what family would she go to? Where would she live? Those are, I think, important questions.
And that's exactly where the unlikely silence hero steps forward, not in a cape but in a jail jumpsuit, ignored by every headline that already convicted her. Actually, wait, I need to slow down right here, just me and you for a second, because this case is doing something to me. Have you ever looked at a mugshot and felt something twist in your gut? That 2023 Facebook photo of Christina and Gary shows them clean, smiling, normal. Fast forward to 2026 and they look hollowed out, broken. I don't know what happened in that house. But I do know this poverty and mental decline are not crimes. And when a 66-year-old woman, whose own attorney now questions her competency to even stand trial, gets held on a fortune bond for something her adult son and daughter-in-law may have allowed, I feel that cold, familiar outrage creeping up my spine. It shouldn't sit right with you either. Something is deeply wrong here, and the system is hoping you'll just scroll past. Now, here's the part nobody talks about. The same day they arrested her, Christina talked. She talked for hours without counsel present. She didn't lawyer up, she didn't clam up. She cooperated. You'd think that would count for something. It didn't. Her attorney is now raising the issue of competency to stand trial, just like the lawyers for Gary Jr. and Gary Sir did before her. 3 out of 4 defendants now have doubts about their own mental fitness to understand what's happening.
So let's dig into these motions filed by Christina Ciders' attorney. I want to bring in Ron O'Brien. He is the former Franklin County prosecutor. The elected prosecutor was for many years in Columbus, Ohio. So Ron, thank you so much for joining me. I appreciate it.
I'm glad to talk with you again about this very interesting case.
Yes, it's very interesting, and we have more questions than answers at this point. So, Ron, talk to me, if you would, about, let's start with the competency request. This is now the 3rd defendant of the 4 in this case who is raising the issue of competency. Are you surprised by that?
No, not at all. I think just by the nature of the offense itself, what's publicly been disclosed, you have to even ask yourself, what are these people doing? What are they thinking? How did this happen? 16 children, or actually 18 children born over a period of 15 years, some of them twins, but wondering what's going on there. And so, as many people will ask themselves, is there something wrong with them? And so I think that itself causes you to think that maybe there should be a preliminary psychological exam of the defendants.
So we have Grandma now. Her attorney, Kanda Roberts, is with the Ohio Public Defender's Office. So they're going to do everything they can to help their client, of course, as any defense attorney would. What's the next step here? I mean, the judge, I'm assuming, Judge Rogers, is going to say, yeah, let's go, let's do it. Let's order the competency evaluation. So what do you see happening as Grandma's competency is evaluated?
I think you're correct that the trial judge will order the competency exam. Sometimes the defense attorney offers more to the judge as a basis to order the competency exam, such as when I visited the offender in the jail. They couldn't tell me about the offense, or they talked about other things, or they couldn't remember things. Kind of the questions that the psychologist is by statute required to look into. But in this case, it was a bare-boned motion that merely said, I have questions whether or not the defendant's competent. Therefore, I'd like to ask for an exam. Despite the lack of reasons being offered, I think the trial judge will order the competency exam, perhaps just based on the offense itself, the age of the offender, and the request by the defense attorney. Because they're obviously, she may have interviewed the defendant for hours in the jail and reached that conclusion herself, but she just doesn't want to talk about it in her motion. So I think it will inquire into those 2 basic questions. Do they understand the nature and quality of the charges against them, which shouldn't be hard, I think, to understand. You're charged with endangering children, causing their harm, and by neglect, essentially. And then the second point that is always necessary is, can they assist their lawyer in providing a defense? And that's more often the basis for someone being found incompetent.
Let's say, let's just do a hypothetical here, that the reviewer and the court find that she is incompetent to stand trial. That doesn't mean that competency can't be restored. We've seen that in a number of cases over the years where somebody is deemed incompetent, then they are sent to some type of institution and they work on them by whatever means that is, to get them to a level where they can assist in their own defense.
I think that's exactly correct. What will happen is, if they order the exam, she'll probably be examined in the county jail, unless this second motion they filed about a reduction in bond that they can post is granted. but she'll be examined in the county jail, interviewed by a psychologist appointed by the court. They will ask her background questions, questions about the offense, questions about her relationship with her lawyer, and usually they administer psychological tests to determine reasoning and understanding, communication. All of those are key things, obviously, if you're charged with a serious crime, being able to talk with your lawyer about. So they give a battery of psychological tests, and that then is part of their report, and then they render the conclusion one way or another. If there would be a finding by the initial examiner that she's incompetent, the state has the opportunity to ask for a second exam. And at least if it would come out contrary to that, the court itself then can appoint a third examiner kind of as a tiebreaker, or can consider the two competing examinations. I recently had a case where the first representing the defendant, or no, in that case, I was representing the victim. Under Ohio law, the victim has a right to their own attorney. And after the first exam, they determined that he was incompetent to stand trial. I asked the prosecutor to seek a second opinion, which they did. And the second opinion reached that they were competent. And the report that that examiner provided caused the first psychologist to change their mind. And there was then a finding that they're competent. So, I used to like to call some of these kind of exams voodoo science, but they're professional opinions by qualified
Sure.
experts. Some of them have different kinds of leanings and biases. But in any event, the first exam is probably the most important, because either side, if they agree with it and it's documented well, it can be accepted and be the basis for the finding of competency or incompetency.
And the judge will likely order psychological evaluations. But I need you to ask yourself, how do you grill a confused, possibly incompetent grandmother for hours, then lock her away and say it's justice? That's not accountability. That's a conviction without a trial. And the breadcrumbs, they just keep piling up. The county prosecutor told commissioners weeks ago that Children's Services will seek permanent custody of all 16 children. That's a huge move this early. It tells me they already decided these kids are never going back, and they need the criminal case to justify it. The Ciders family bounced between addresses too. Before the Omar Street house, they lived on Honeysuckle in Gallia County. Truancy charges were filed there for the school-aged kids, but they never went anywhere because officials couldn't find the family to serve them.
There's still the fact that these people shared addresses in Gallia County. So they were living together at a house on Honeysuckle in Gallia County when the truancy action was filed. So these people have been living together for a really long time.
Right, and you would think also with regard to that issue that a grandparent would understand that it's in the child's interest and required by law that they attend school when they reach a certain age. And most of the children, or at least more than half of them, are over that mandatory minimum age. And as we talked about last week, they in fact had truancy charges filed on them that never went forward because they couldn't get service. So either they left that place and didn't leave a forwarding location in Gallia County, or the sheriff's office or children's services down there, or the truancy officer. Each school district by statute has the ability and does appoint what they call a truancy officer. And so all of them didn't follow up once they filed the charge.
Mm-hmm. Yeah, it's really something. You would think that Gallia, when they tried to do that, would try to put out be on the lookout or something. But I don't know how all of that works. We don't do a lot of truancy cases here on Law and Crime, but now we're dealing with one.
You see the pattern. The system failed these children long before June 30, 2026. And now, to make up for it, they're sacrificing the grandmother on a pyre of righteous outrage. If the evidence was so damning, why seal the search warrant affidavit? Why fight to keep it hidden all the way to the Ohio Supreme Court? I'll tell you why. Because What's in there might expose how thin this case really is. This is bigger than Vinton County. This is the same broken playbook we've seen over and over. The state overreaches, the media runs with the most horrifying soundbite, and by the time the truth crawls out, lives are already destroyed. The therapeutic foster care industry gets 16 new placements. The sheriff gets his press conference. The justice system pats itself on the back while a grandmother with documented medical diagnosis and possible cognitive decline sits in a cell, costing taxpayers money, waiting for a competency exam that might take months. They blackballed her name before a single witness testified. They buried the evidence under seal. And you and I were supposed to just trust the process. We're not that naive. Not anymore. And this is the part that sticks in my throat. Her attorney laid it out. Christina has no resources to flee. She has family support outside that house. She'd wear a GPS monitor. She needs medical treatment for her mental condition, treatment she cannot get inside a county jail.
If she's granted bail, Roberts wrote, defendant has strong family support. In fact, in release, defendant will reside with close family members who are capable and available to assist in ensuring defendant's appearance at future court proceedings and defendant's compliance with any conditions of pretrial release imposed by this court. Defendant's financial resources are limited as demonstrated by her indigent status. As such, she has no resources or access to means which would make her a significant risk of flight to avoid prosecution. Defendant has resided in southeastern Ohio all her life. Defendant has no family or other connections outside of the area. Defendant requires medical treatment related to her mental condition and many documented medical diagnoses, all of which can be addressed while defendant is not incarcerated in jail. Roberts continued, writing, none of the statutory or constitutional factors relevant to this court's consideration of defendant's request that she be released on bail weigh in the state's favor. Rather, each and every factor weighs heavily in defendant's favor. Defendant poses no threat to the public. Defendant is not a flight risk. Defendant's lack of criminal history, age, medical concerns, family support, attorney-client relationship, and condition that she will be placed on GPS monitoring in release.
Yet the state has not even responded to the motion to modify bail. Silence.
As of now, all three defendants, Christina, Gary Jr., and Elizabeth, remain in jail on that $300,000 bond. Prosecutors have not responded to these motions filed by Elizabeth's attorney and Christina's attorney.
The prosecutor's office, the same one seeking permanent custody of the children, won't even argue in open court why this woman must remain caged. That silence is deafening. It tells me they don't want a public airing of their evidence because once the light hits it, the whole narrative crumbles. I need you to stay with me here because the final isn't a verdict. It's a question that should keep you up to if a 66-year-old grandmother with no criminal past, strong community ties, and serious questions about her own mental competence can be held on an impossible bond while sealed documents hide the state's case from the public. What does that say about the system you're funding with your tax dollars? They want you to think this is about saving children. Maybe it started that way, but it has curdled into something else, something that reeks of career advancement and institutional cover-up. The children are already in state custody. The real parents are locked up, and the grandmother, the one person who might be little more than overwhelmed bystander in a family tragedy, remains the forgotten face of this case. So here's my direct question to you, and I'm not asking rhetorically. I want your voice in the comments. Is this justice, or is this a public sacrifice to distract from a decade of failures by children's services and local law enforcement? You tell me. Because right now, Christina Ciders waits in that jail, and not a single official can point to solid evidence that she personally harmed a child. That's not how a righteous system operates. That's how a system buries its own incompetence. And we're watching it happen in real time.